Good afternoon, everyone. My name is Diego Cartagena, and on behalf of the SoCal Pro Bono Managers, I'd like to welcome you all to our third annual Pro Bono Week celebration. Thank you all very much for being here. Before I turn it over to my colleague, Lori Arnoff, to introduce our esteemed moderator, I want to take a moment to thank our co-sponsors, the LA County Bar Association, as well as the LA County Bar Association's litigation section, and the Los Angeles County Bar Association's barristers section. Thank you very much for making today possible. We appreciate it a great deal. For those of you that are not familiar with the Southern California Pro Bono Managers Group, we have information on the back table regarding our organization and our association. We also have information at the back table regarding the various organizations with which you can volunteer. We have flyers, informational packets, as well as information for the SoCal Pro Bono Managers website. And you can see some of the information here on the slides. And finally, I'd like to mention that October is also the Campaign for Justice month. And for those of you that are interested in learning a little bit more about the Campaign for Justice, the website is www.caforjustice.org. And this campaign is designed to raise funds and awareness regarding the need for access to justice for all individuals, regardless of their income. And so there's more information regarding the campaign at the back table. Again, thank you very much, and I'd like to introduce Lori Arnoff.
Before I introduce our esteemed keynote speaker today, I did also want to just introduce very quickly Eric Weber, who's the LA County Bar President. Really honored to have Eric here today and to welcome you here.
Thanks, Lori. Thank you all very, very much. As Lori said, I'm Eric Weber. I'm a partner at Irela Manila, and I have the great privilege this year of being president of the Los Angeles County Bar. And to echo and return what Diego said, we are honored and delighted to co-sponsor this event with the Southern California Pro Bono Managers, and particularly interested in doing so during Access to Justice Month, which we at LACBA recognize and support because we're acutely aware of the already great but now growing need in our communities for legal assistance. And we're also acutely aware of the shortage of financial support and other support for that need. That increasing gap between the need and the support and resources available is a cause of concern for us at LACBA and for me personally. And one of my priorities this year during my presidency is to make sure that we do all that we reasonably can to address it. Hosting programs like this, encouraging our members to get involved in pro bono service, both through LACBA's own projects, including the one that Lori works on, our AIDS project, our domestic violence project, our immigration project, and other projects that provide services, as well as the many organizations who provide extraordinary services, all represented on our Access to Justice Committee. We want to support and help you and be part of the pipeline to get pro bono volunteers to your organizations, to your projects, to meet that great and growing need. So I thank all of you for being here today, and on behalf of LACBA, God bless you all for the good work you do.
So on behalf of the association, I've been working with the Southern California Pro Bono Managers Group now for a number of years, and we're a very collaborative group. We do everything by consensus. We're very egalitarian. And when we decided several years ago, when the ABA launched this idea of a National Pro Bono Week, and we knew we wanted to do an event, somebody in the room, I don't recall who it was, said very simply, I wonder if we can get Irwin. And it was this immediate buzz about, oh my gosh, can we get Irwin Chemerinsky to come and address whatever he wants to talk about? It's certainly fine with us. I was a little daunted to do the introduction. Obviously it would be easy enough to find Dean Chemerinsky's bio. Launching the inaugural dean, if you will, of UC Irvine's Law School. We all know that they got their what's it called, the preemptive accreditation this last summer. He has amassed an amazing faculty. If anyone's had the pleasure of working with the law students, we can tell what kind of impact they're going to make as lawyers in the community. The bedrock of sort of the academic freedom is just sort of permeates the school. but his ties, I think, from the heart. We don't have, I don't think, that many heroes. I know there's a lot of legal service attorneys in the room today, and a lot of us have been sort of toiling away, if you will, fighting the good fight, trying to do right for the underdog, and to have somebody standing with us with the stature and the scholarship of Erwin Chemerinsky is just such an honor. From the Constitutionalist textbook that he has written that everybody is required to read, to his impact, his arguments before the Supreme Court. Who can forget Guantanamo Bay, three strikes law in California, helping to rewrite our city charter. The list just goes on and on. But I think very succinctly, and he's had his head down the whole time, so I don't know him personally, but it's been an honor emailing him. He's obviously an incredibly modest man. But I wanted to quote Catherine Bartlett, who is the dean of Duke Law School. When she was able to lure him away, as we all know, for just a few years, she said it very succinctly. Erwin Chemerinsky is one of a kind, a first-rate constitutional law scholar, extraordinary teacher, highly visible public intellectual, and a serious lawyer who finds time to advance the legal reforms about which he is most passionate. So without further ado, Dean Chemerinsky.
Thank you for the incredibly kind introduction. It's really an honor to be with you. I apologize for being a few minutes late, but I learned a very important lesson in the process. I've now lived in Orange County long enough to know to leave a long time when I'm driving for something in Los Angeles. And I did that. I've been to this building for county bar events twice in the last month, but I have a terrible sense of direction. So I always go onto Google and print Google directions, and I follow them exactly. And the Google directions that I took with me said that take 6th Street exit, and then go onto 6th Street and go to South Spring Street. Take the first left onto 7th Street. And I did exactly that, and I was nowhere near here, but being tied in all the streets. And then when I realized what I'd done wrong, I typed 155 West 7th Street rather than 1055 West 7th Street. And of course, the lesson in that is, if you're going to use Google, you've got to type the address in right. So I apologize, but it's been an amazing last half hour. 13 years ago this week, I had the pleasure of going to Russia to participate in an international judicial conference. The conference was held in Ulyanovsk, which was Lenin's birthplace, and involved judges and academics from all over the world. We met in a courthouse there. Though it was just the end of October, it was very cold. There was no heat in the courthouse. As we would talk, we could see one another's breath. Finally, one of the federal judges in our group, with the understated manner that only a federal judge can master, went up and said, "Can't you turn on some heat here?" To which the response was, "No, we don't have any money for heat at this point in time." In the courtrooms where we were meeting, we saw that there were cages, literally enclosed with bars. And we asked, what's the purpose of the cage? And they said, well, when there's criminal trials, that's where the defendant is placed. And one of the things was being talked about how Russia was wanting to go to a jury trial system. And one of the points that we gently made was it might be very prejudicial in front of a jury to see the defendant literally sitting in a cage. And the answer that we were given was, we don't have any money for security in the courtroom, and the only way to provide security is to put the defendant in such a cage. To say that the buildings were shabby would really to compliment them. The linoleum floors that were worn out, the seating was the kind that you certainly wouldn't want in anything resembling a major branch of government. And I'm sure that the Americans who were there couldn't help, even just subconsciously, feeling smug about how different our courts are compared to what we were seeing. And yet, as I read day after day, week after week, month after month, the budget cuts that our courts are undergoing in the United States, I wonder how far we really are from this. I was asked to speak here, and I got in touch, and I said, well, what would you like me to talk about? And the answer was anything regarding access to justice. And I thought what I wanted to speak about was something that's just not getting nearly enough attention. It's what's truly become a major crisis in funding our courts. And the reality is that access to justice is impeded because of the crisis in funding the courts. And we need to think about how we're going to solve this and what we're going to do about it. So I thought what I would address, and I'll try to be very brief, is three questions. What is the crisis in funding the courts now, and why is it going on? Second, to what extent can be argued that, and when is this unconstitutional? And third, what might we do about it? I certainly don't come to you with any definitive answers. And those of you who are judges and appearing in the courts see what I'm talking about every day. But I do think that it's something that's not getting nearly the attention that it should, either here in California or across the country. So let me start by talking about, well, what is the problem in funding the courts? I got the statistics just from California, and I know some of you know them by heart. This year, the legislature, on the recommendation of the governor, initially cut $200 million in the funding for the courts in California. And then when that proved inadequate as part of balancing the budget, another $150 million was cut from the budget of California courts. In addition, at least $300 million in post-construction was put on indefinite hold. David Boies, the renowned lawyer, said, nationally, we are long past cutting fat, we're now cutting muscle and bone, and certainly this is true. There's, of course, as we know, living in California, a great irony to this. It's not only the courts that have suffered this. The University of California, that I'm now a part of, had a $500 million budget cut at the beginning of this year, followed in June by another $150 million budget cut, and we're all worried about what the next trigger cuts are going to be. But, of course, at the same time, not one penny has been cut from the California prison system, while we're seeing these cuts with regard to the California courts and California education. I have seen that in 2013, Los Angeles may need to close 180 out of 605 courtrooms. There's talk of laying off 1,800 employees in the courts in Los Angeles County. That's 34% of all of the employees in the courts. It's estimated that Los Angeles may need to close 42 criminal courtrooms. In San Francisco, the funding crisis is even more acute. This year, they've been talking about closing 25 of 63 criminal courtrooms. They've been talking about having to lay off 40% of the staff in the San Francisco courts. Now, this was temporarily avoided by, on September 1st, $3.15 million in emergency funds being given to the San Francisco courts, but it's only temporary. I recite the California statistics because this is where we are, it's what we're most familiar with, but it's a national problem. In Massachusetts, they've just cut 10% of the funding from the courts. They've laid off 740 people. There's a very frightening incident a year ago in Worcester, Massachusetts, where because they had laid off security guards, there wasn't adequate security, and both the judge and those who were in the courtroom were placed in danger. This past July, I had the wonderful opportunity of going to speak to a judicial conference of the judges in the Virgin Islands. And after I did my presentation, the judges of what we regard as their state court came up to me and said, at what point does the cutting and funding of courts violate separation of powers? And the reason that they were asking was that very afternoon they were going to talk before the Virgin Islands legislative body that was going to cut their funding and did cut their funding over 10%. I could go state by state, could talk about Connecticut, Florida, New York on the East Coast, Washington, California on the other. Overall, 40 of 50 states have had significant funding cuts in just the last year. I want to take a moment and ask, why is this happening? Now, there's the obvious answer of, well, this is going on because of the budget problems that are being faced in California and across the country. And undoubtedly that's true, but I think that's too simplistic an answer, and I think it's an answer that obscures the need for much more long-term structural thinking. I think part of the reason why there's the problem in funding the courts is the lack of political influence of the judiciary in the electoral process. Think about what the electoral process responds to. Votes, and of course dollars in campaign contributions. Judges can't bring votes to bear with regard to the legislative process, and to be sure, judges and those who support the courts can't bring campaign contributions to bear. Prison guards can put a lot of pressure on legislators. They have a lot of dollars and can even marshal some votes with regard to their endorsements. And that may explain why the University of California has cut $650 million this year, the California courts $350 million, and not a penny from the prison system. but it is the very nature of the judiciary that is particularly ill-suited to be able to succeed in the political process. I think there's a second explanation for what's going on here that needs to take account, and I think that the increase in privatization of civil justice contributes to this. Think what's going on with regard to public health. Public hospitals are generally those that are gone to by people who can't afford the private healthcare system. Relatively few people who can afford private doctors and private hospitals would make the choice to go to public hospitals. The result of that, of course, we've seen, is that public hospitals become increasingly inadequate. I think we're seeing the same thing going on in education in the United States. As those with resources can send their children to private schools, or at least to high-quality suburban schools, there's ever less incentive to adequately fund the public schools. When a dual standard is set up, and those with resources can opt out of the public arena is inadequately funded. We've certainly seen the increase in privatization of civil justice over the last decade or two. I wonder if every legal matter had to go to court, if we would have the same crisis in funding that there is today. If it isn't the case that many of the lawyers in law firms that can now go to private arbitration might then be those who would really press for more adequate funding in the public justice system. I think there's another explanation here that also has to be discussed, and it's much more systemic. And it's a lack of willingness in our society to pay taxes for the government that's essential. I think the crisis right now is that people are unwilling to pay the taxes for even the most basic government services. I listened to the rhetoric of some of the candidates when they declared for the presidential nomination, and how they said that government is inherently evil. People should be able to keep all of their own hard-earned money and not have to pay taxes. And the result of this, I think, is a mentality that led to that we don't have taxes that are adequate to support even those basic government services. When are people going to realize that government isn't the enemy? That when people want the divorce, when people are dealing with a child custody fight, when people have a will they be probated, they need the courts to be there and be open. And we go on with obviously all of the other things we depend on government to do, whether it's air traffic controllers to make sure that the planes are flying, or welfare programs to take care of those who really need the safety net, or just people to inspect the food and the drugs to make sure that they're safe and make sure that they can protect our health. And I worry that the lack of funding of the courts is a reflection of this much larger social and systemic problem, that we're not willing to pay enough taxes to support the government that we need. Courts, higher education, education at all levels is suffering as a result. Well, if we can all accept there's a crisis, and can you accept some of my explanation of why, what I want to talk about next is, when does the crisis in funding the courts violate the Constitution? There has to be a point at which the lack of funding violates individual liberties. There has to be a point at which the lack of funding violates separation of powers. And it's interesting how little scholarship among law professors has been about this, how little writing there's been about this. I can point to only a handful of cases where the issue has been raised. But it does seem clear to me that there's a point at which, if there's not enough funds, then the constitutional rights of individuals are being violated. Think of the Sixth Amendment. The Sixth Amendment guarantees a right to a jury trial. The Sixth Amendment guarantees a right to counsel. The Sixth Amendment guarantees a right to speedy trial. All of those require that there be adequate funding. There is an enormous crisis in many states with regard to the adequacy of funding of public defenders. This, again, is a Sixth Amendment guaranteed right. It's estimated right now in the state of Mississippi that a lawyer handling a death penalty case is paid an average of $11 an hour. It's estimated in Alabama that a lawyer handling a death penalty case is paid $15 an hour. In many states, the compensation for public defenders or appointed counsel has not been increased in years, and thus the lack of counsel or lack of competent counsel is acute. Courts are going to have to deal with this. But the Seventh Amendment also guarantees a right to jury trial in civil cases, and it too costs money. there are a few instances in which government entities have tried to suspend the right to jury trial in civil cases as a way of saving money. The Ninth Circuit dealt with this in the context of Alaska, interestingly in its federal court, temporarily suspending jury trials to save money. And the Ninth Circuit declared this unconstitutional, a case called Armster versus the United States. In the words of the court, they're dealing with the Seventh Amendment can apply to so many areas that relate to what we're talking about here today, access to justice. The Ninth Circuit wrote, the availability of constitutional rights does not vary with the rise and fall of account balances in the Treasury. Our basic liberties cannot be offered and withdrawn as budget crunches come and go. Constitutional rights do not turn on the political mood of the moment, the outcome of cost-benefit analysis, or the result of economic or fiscal calculations. Rather, our constitutional rights are fixed and immutable. The constitutional mandate that federal courts provide civil litigants with a system of civil jury trials is clear. There is no price tag on the continued existence of that system. We conclude that the civil jury trial system may not be suspended for lack of funds. Specifically, we conclude that the Seventh Amendment right to a civil jury trial is violated because of such a suspension, an individual is not afforded for any significant period of time a jury trial he would otherwise receive. But what about the instances where the juries aren't available for a long period of time? That the lack of funding of the court means that civil cases are largely put on hold and jury trials don't happen. Doesn't that violate the Seventh Amendment? Now, I focused on the Sixth and Seventh Amendments because they enumerate specific rights. It'd be easy to say that they are rights that depend on money. But think of due process under the Fifth and 14th Amendments and what's required in terms of due process with regard to access to courts, to the extent to which that depends on money. And the question then is, when does the lack of funding so impede access to justice as to violate due process of law? The reason I talk about this today with you is this is the question that we need to be focusing on. I don't think it's hypothetical. I don't think it's far into the future. I think we're seeing it now, we're seeing it here, and we're seeing it every day. Now, there's also the point at which the lack of funding of courts violates separation of powers. The judiciary, after all, is an independent and co-equal branch of government. What if, for example, Congress were to decide, as if you read the New York Times on Monday, some of the Republican candidates for president are urging, that Congress simply not fund some or all of the courts? Wouldn't that be clearly and unquestionably unconstitutional? Article 3 says there will be a Supreme Court, and such lower federal courts as Congress from time to time will ordain and establish. It says that the federal judges can't have their salaries decreased during their term of office. Now, I have focused on the state courts, but I think there's a very strong argument that the failure to give pay increases to federal judges and the denial of cost of living increases year after year is part of a violation of separation of powers. Federal judges now are making less than entry-level law professors at many top law schools. Nobody's saying that federal judges should be paid the same as partners at major law firms, but at least they should get the same as entry-level law professors. We've seen terrific federal judges leave the bench because of the lack of adequate salary. I think of Stephen Larson here in Los Angeles, and Stephen was my student at USC Law School, was in private practice, an assistant United States attorney, an esteemed federal magistrate judge, and then a terrific federal district court judge. And he announced his resignation and said that he has children he's sending to parochial school and he just can't afford to do it on a federal judge's salary. He's not alone. We could give example after example across the country of people who have left the federal bench for that reason. And how many terrific judges never were considered because they simply couldn't afford the pay cut that would be entailed. That, to me, is what we're talking about with regard to separation of powers. But there's the more general question of when does the lack of funding of the courts violate separation of powers? The difficulty is there's never going to be a magic line to be drawn. There always will be great discomfort when it's judges declaring the lack of funding of courts is unconstitutional. So I think there needs to be thought of what's the constitutional standard here. As I was reflecting on this and preparing to talk to you, I was reminded of a very famous law review article actually the most frequently cited articles in all of American history, by Harvard professor Henry Hart. It was the 1954 foreword to the Harvard Law Review. And the issue that he was addressing is, when does congressional restriction of Supreme Court and federal court jurisdiction violate separation of powers? That's not the issue I'm talking about, but I think his solution to that question applies here. He said that Congress can't limit the jurisdiction of the federal courts in a way that undermines their ability to perform their essential functions. Well, likewise, I would say a legislature can't cut funding of the courts in a way that keeps it from performing its essential functions. We in this room could come up with a list of what are the essential functions that we expect courts to do. Many of those essential functions, of course, are about access to justice. At the point at which there's not adequate funding for those essential functions, isn't there then a violation of separation of powers? And isn't it the role then of the judges, however uncomfortable it may be, to say that this is unconstitutional? So this brings me to the third and final part of my remarks. What might we do about it? What's the solution? Well, let me offer several tentative ideas here. Well, first is, obviously, we have to look for ever greater efficiencies in operating the courts. You might have seen an issue of the American Bar Association Journal, and the cover story was 10 ways of greater efficiencies in funding the courts. My guess is that almost all of them are being done in almost all courts already. That my instinct, and many of you work in the courts, is that long ago the courts captured the efficiency savings they could. There's not a lot more that can be done. But I do think that here law schools deserve part of the blame for lack of solutions. I'll tell you a story. We're talking with somebody who's potentially going to give my law school a large gift to create an institute on judicial administration. So when we began discussing this with him, I decided I wanted to do research about, well, what other programs exist in the country, and the gift would include enough money for a chaired professor. So who might be the big stars in the field that we might recruit to come to UCI Law School? I discovered there are no institutes in law schools in the United States that study judicial administration. Now, NYU has a wonderful program, but it's primarily focused on teaching judges. Some law schools, like the University of Denver, offer master's degrees with regard to judicial administration, but these programs don't engage in any systematic research with how to improve the efficiency of the courts. I looked for any tenured professor at a major law school who was focusing on judicial administration in his or her research. I couldn't find one. Now, if you know of some, let me know, because we may have a job for them. But doesn't that say something quite frightening about American law schools today? That law schools aren't paying any attention to how to administer the courts? I mean, law professors, unlike judges and lawyers, have the time. It's their job to do research. Shouldn't we be the ones who are doing research about how to improve the administration and function of the court? Obviously, we have to do it in partnership with lawyers and judges. But I think this is one direction that law schools need to do better. Second, we've got to look for ways of having more political influence in the legislative process for this. I think a starting point is that we've all got to begin talking about the crisis in funding the courts. That occasionally we'll see an article about this or that being cut, but there certainly hasn't been any systematic campaign that's been launched by the state bar, to my knowledge by the county bar, to really focus on pressuring the legislature to restore the funding cuts, and certainly not to cut any additional funding with regard to the judiciary. The new president of the American Bar Association, Bill Robinson, has made this the signature effort for his term, and hopefully the ABA will begin to do something in this regard. But I do think that lawyers need to think about how can we organize to be the pressure group in the legislature for adequate funding of the courts. Because, again, every time the courts' funding is cut, for us as lawyers, we're the ones, our clients are the ones who are really going to suffer. It's access to justice that's really going to suffer. I think third, we need to think about effective litigation strategies. That there are going to be times when it is necessary to go to courts and argue that the cuts in funding, the denial of access, the lack of adequate dollars for the judiciary violates the Constitution. We saw that this summer. You might remember that there was a stalemate in the Minnesota legislature with regard to government, and they closed down the Minnesota government for 3 weeks. And on June 28th of this year, Judge Bruce Christensen of Minnesota said that the judiciary would be exempt from this and that the judiciary was an essential function and would continue to operate notwithstanding the rest of the government shutting down. He invoked separation of powers. I can point you to a handful of cases, but certainly not many more than I could count on the fingers of one hand, where courts have found that the lack of funding violates the Constitution. We need to think about how should we best litigate those cases. Where are the places that the challenges can and should be brought? And here I think we need to focus on both the U.S. Constitution and state constitutions. For state constitutions guarantee rights as well. In many states, there are access to justice provisions in the state constitutions, and those may be even more fruitful places to litigate than under the United States Constitution. And finally, I think the challenge for all of us is, how do we better create a culture and society that's ready to provide adequate funding for essential government services? How do we change the social debate so that no longer is government regarded as evil? So no longer do candidates say no tax increases no matter what. Because so long that's the mentality, there won't be adequate funds for education or, for that matter, the court. In this way, as I said earlier, I think the lack of adequate funding of the courts is reflective of a much larger social problem, and we as lawyers need to be a part of that. People always talk about, in Tammany Hall, they remarked on how they had the best judges that money could buy. I worry that we're now seeing the flip side of that coin. We're seeing all of the problems when we don't have money to buy justice for people. And so the reason I wanted to talk about this is, if we're going to focus on access to justice, we really have to focus on funding for the courts. Thank you.
Thank you, Dean Chemerinsky. We really appreciate you coming up and sharing your thoughts with us today. We're going to open our panel, and the Dean is going to continue to moderate the panel for us. We want to introduce our judges that we're honored to have with us today. The Honorable Nora Minella, and Judge Suzanne Siegel, and Judge Kelvin Filer, and Amy Pellman is not able to join us today. So, by way of a very brief introduction, Judge Minella serves as the Associate Justice of the California Court of Appeals. And prior to her appointment, she served for 7 years on the federal bench, United States District Court District Judge in Los Angeles, and before that as a U.S. Attorney in the California District of Court. She had a clerkship at the beginning of her career with Judge John Minor Wisdom in the Fifth Circuit, and then worked as counsel for the Senate Judiciary Subcommittee on the Constitution before practicing complex civil litigation at O'Melveny and Myers. Judge Filer grew up in the Compton neighborhood in 1960s and came to the bench in 1993. He's a graduate of Bolt School of Law, and he currently serves on the California Superior Court as of 2002, when he was appointed by then Governor Gray Davis, and he continues to serve at the Compton Courthouse. He began his career in the State Public Defender's Office and then entered private practice in Compton. And Judge Siegel was appointed as a United States Magistrate Judge for the Central District of California in 2002. She presides over a federal civil and criminal proceedings, and before taking the bench, she served as the Assistant United States Attorney in the Civil Division of the Los Angeles U.S. Attorney's Office from 1990 to 2002. Prior to serving in the U.S. Attorney's Office, she was an associate at Dewey Ballantine. I will leave it at that, and we thank you very much for coming today and sharing your expertise and your wisdom with us, and I will turn it over to Dean.
And my name's still Erwin Chemerinsky. The focus for this discussion is bias. And what I'd be interested in starting with is asking each of these judges who come to you from different courts, state trial court, federal trial court, state court of appeal, what they perceive as the main problem with regard to bias in the current legal system, and then go from there. Judge Manella?
I wouldn't want to say that I've made up my mind on this subject, demonstrating bias, but I'm not sure that I think of judicial bias as a particularly pressing problem in our system today. Certainly funding of the courts is a far more serious problem. And before one even addresses that, I think one has to decide what you consider bias. I mean, we all know it's a very complicated subject. If knowing a lot about a subject leaves you with some firm impressions about how the world works, that may not be bias. That may just be being informed. On the other hand, we all know the horror stories of a judge who announces at the beginning of a proceeding that he or she has made up his or her mind and doesn't want to hear any of the evidence. So I'm not sure I think of judicial bias as one category of a problem, and until one defines it, I'm not sure one can assess just how serious it is.
Let me back up just 1 second and ask a quick follow-up question. Putting aside judges being biased, do you see any systematic biases in the courts in the way they treat litigants?
The courts.
You were a federal district court judge, state court of appeal
I
justice.
never exhibited the slightest
You
bias
never
in
did,
any.
but did you observe bias?
Well, again,
I know,
look,
define.
I
right,
came into the
bias.
federal. Most of my career was spent in the federal judicial system, and I came in as an assistant United States attorney, a federal prosecutor, before the sentencing guidelines. And you know, if anyone had said to you in those days, "Gee, what do you do if you get a biased judge?" You'd say, "Suck it up." You know, see Article 3. You got the judge. I mean, everybody knew the jacket of every judge on the Central District bench. And as I was saying to Eric earlier, what you wanted was a judge who was at least predictable. If you drew Bill Gray and you were defense counsel, you turned to your client and said, "This is your ducky lay. You know, this is good." If you drew certain other judges, you were not so lucky. But as in life in general, the people you're dealing with, you know, some may be more naturally receptive than others. It was just kind of a given that that's the way the world worked. The judges were different. They had enormous discretion, particularly in criminal cases and in sentencing, and you adjusted accordingly. Now, obviously, the guidelines, for better and often for worse, have limited the discretion of judges, so it's perhaps not as big a deal. But certainly there were judges who were known as being harsh on defendants, more likely to sentence more harshly in certain kinds of cases. Again, I'm not even sure whether that's bias or whether that's just life.
Judge Siegel, do you perceive, and again, you define this not about biased judges, though we can talk about that if you perceive that, but the court system, are there biases there?
Well, I would say two things. I would say, one, when I started in federal court, which was 23 years ago, I think that, and I'm thinking now of like the kind of bias that's truly prohibited bias based on a protected characteristic, that there might have been judges who lawyers thought had a bias against a particular race or gender or some other group of people. And there might have been careless times when the judge made a comment that led lawyers to believe that, or a pattern of ruling that led lawyers to believe that. As we went forward in time, that kind of conduct became so prohibited and so frowned upon that it has definitely lessened in the 20 years that I've been there. And I think now today, that just doesn't happen. A judge just doesn't make that statement on the record. There isn't kind of the wink-wink or comment about a female attorney, for example. It's just never made. And our bench has diversified significantly in 20 years. So I think diversity on the bench works to counter whatever possible bias there may be in a judge's behavior. Having said all that, I believe that bias is somewhat like jealousy and anger. It's sort of a human emotion. And while it may not be obvious from the record anymore, or may not be obvious or perceptible, it occasionally is there. And I think that it's become trickier